General Secretary of the PPP, Bharrat Jagdeo, lashes out at President Granger after the president accused the party of electoral fraud.
I'm tempted to take that tone of totally disparaging what he said and criticizing it as somebody who is delusional, out of touch, and being fed propaganda by his staff.
Students in Santa Rosa COVID-19 hotspot still have to sit national grade 6 examinations this week. And in sport, newcomer Chamar Holder ready to grab test spot on England tour. With the news, I'm Avinash Ramzan. Thank you for joining us. We started by telling you that with Venezuela maintaining a claim to 70% of Guyana's territory over its argument that the arbitral award, which over 120 years ago determined the boundaries between the two countries, is null and void, a high-level legal team representing Guyana on Tuesday made out a case on why the International Court of Justice has the powers to hear and determine the case brought before it to put an end to the controversy. After 6 decades of accepting the agreement, Venezuela in 1966 repudiated the agreement and said it was null and void. The parties signed the so-called Geneva Agreement in 1966 to determine a final settlement of Venezuela's claim about the award. After a last push to see if the talks could bear fruit between the two countries failed, the United Nations Secretary General Antonio Guterres on January 30, 2018 announced that he was referring the matter to the International Court for final and full settlement. But Venezuela contends that the Secretary General was not correct in taking the decision, saying that it wanted talks to continue. But Guyana, exhausted by decades of talks that produced no results, moved to the court to settle the controversy. But Venezuela has argued that the court has no jurisdiction and did not participate in the oral hearings on Tuesday.
What matters most, and this is a matter of public record, is the conclusion of the Secretary General. Despite a full year of intensive efforts, there was no discernible progress towards a resolution of the controversy arising from Venezuela's contention of nullity. And so, on January the 30th, 2018, consistent with what he had communicated to the parties on December the 15th, 2016, the Secretary General issued a public statement and sent letters to each of the parties. He announced that he had chosen the court as the next means of settlement. Despite the intensive efforts, the Secretary General had concluded, and the words are to be found at tab 20 of your folder, significant progress has not been made towards arriving at a full agreement for the solution of the controversy. Accordingly, the Secretary General has fulfilled the responsibility that has fallen within the framework set by his predecessor in December 2016 and has chosen the International Court of Justice as the means to be used for the solution of the controversy. End of quote. Mr. President, members of the court, the record is clear. More than 50 years have passed since the signing of the Geneva Agreement. 4 years were fruitlessly spent before a mixed commission from 1966 to 1970. 12 years were then spent on an equally unavailing suspension of the Geneva Agreement from 1970 to 1982. 37 years ago this week, Guyana and Venezuela jointly entrusted the Secretary General with exclusive, unfettered, and irrevocable responsibility for selecting the means of settlement of the controversy. After 6 years of further discussion between the parties and the Secretary General's representative, the good offices process was established in 1990 with an enhanced mandate of mediation for the year 2017. That means of settlement ran its course for more than a quarter of a century. It has produced no progress whatsoever. Nothing. Rien. The existence, basis, validity, and nature of the Secretary General's right to select that process has never been called into doubt. To the contrary, Venezuela and Guyana have repeatedly and consistently reaffirmed the Secretary General's exclusive responsibility and right under the Geneva Agreement to select the means of settlement. Venezuela has never previously disputed the Secretary General's discretion to select the means of settlement from those listed in Article 33 of the United Nations Charter. The good offices bore no fruit. In 2018, the Secretary General concluded that significant progress had not been made towards resolving the controversy. We say that conclusion was reasonable and it was justified. In those circumstances, the Secretary General was plainly entitled, and indeed, we say positively required by the words of Article 4, Paragraph 2 of the Geneva Agreement to, I quote, choose another of the means stipulated in Article 33 of the Charter of the United Nations, end of quote. Another in the singular. The Secretary General's choice of judicial resolution by the court was reasonable. It was based on legal advice, and it was and is lawful. The Secretary General simply could not be expected to go on forever and ever with a hopeless and useless exercise. He did not take an impermissible shortcut, as Venezuela puts it in its recent memorandum. Rather, after decades of futile negotiations and mediation, the Secretary General concluded, in the exercise of the responsibility, rights, and discretion granted to him by the Geneva Agreement, that the next means of settlement shall be judicial resolution by an independent tribunal applying the rules of international law. The Secretary General proceeded with the utmost care and deliberation. He had a number of options available to him. He chose this court, the principal judicial organ of the United Nations. That was a first. It was a reasonable choice. It was a sensible choice. And it fell fully within the discretion conferred upon him by the parties under Article 4, Paragraph 2 of the Geneva Agreement.
The parties presented a massive volume of documents on effectivité, covering 300 years of Spanish, Dutch, and British rule in the disputed territories. On 3 October 1899, after extensive deliberations, the tribunal established the boundary in unanimous award. The result was widely hailed as a victory for Venezuela. The Venezuelan minister in London described it to his Minister of Foreign Affairs in these words: "Greatly indeed did justice shine forth when in the determination of the frontier we were given the exclusive dominion over the Orinoco, which was the principal aim which we sought to achieve through arbitration." The following year, in 1900, Britain and Venezuela established a joint commission to undertake the physical demarcation of the boundary. By 1905, after years of arduous work, the boundary was demarcated with pillars and geographic features stretching 825 kilometers from the Caribbean coast to the tri-junction point with Brazil in the Amazon basin. The Commission produced an official boundary map with the clear specification of the boundary line with the Arbitral Award of Paris, according with the Arbitral Award of Paris. This map appears at tab 2 of the judge's folder. The 1905 map was exceptionally accurate. It followed 15,440 points from the monument at Punta Playa in the north to the top of Mount Roraima in the south. Those points are confirmed by modern satellite imagery.
That day in Paris, at the end of the 19th century is now a long time away. 120 years have passed since international law spoke. During that time, colonization in British Guyana came to an end, and Guyana has now enjoyed more than 50 years of independence. That might suggest a rather ordered past, given that the boundary was definitively settled a long time ago. But that would be wrong. In a word, we are here because, contrary to international law and to the binding award of 1899, the Bolivarian Republic of Venezuela, our neighbor to the west, has cultivated a nationalist passion to disavow that day in Paris and lay claim to almost 3/4 of Guyana. It was not always so. The arbitral proceeding in Paris was, after all, instigated at the behest of Venezuela. And Venezuela enjoyed and continues to enjoy the gains brought to them by the arbitral award. Yet, the process that brings us here is rooted in Venezuela's repudiation of that award. Repudiation more than 6 decades after it was handed down, at a time that seemed propitious to it, the very eve of Guyana's independence in the 1960s.
And President David Granger on Monday night said he was prepared to live by the election's results when it is declared by the chair of the Guyana Elections Commission. And though he continued his mantra of not interfering in the work of GECOM, he said the commission is bound by the report it is given by the Chief Elections Officer, Keith Lowenfield. Kurt Campbell joins us now with details.
President David Granger has offered his support for the latest report submitted by Guyana's Chief Elections Officer, Keith Lowenfield, in which he invalidated some 115,000 votes and in so doing did not prepare a report based on certified figures from the national recount exercise as he was instructed to do. The results of the recount showed that the opposition People's Progressive Party won the elections, and it was these figures that the chair of the Guyana Elections Commission, former Judge Claudette Singh, has asked for Lowenfield's report to reflect. Granger, speaking on a radio program hosted by Mark Benchcock Monday night, said that Lowenfield was obligated to include in his report the anomalies and irregularities which arose during the recount, and GECOM was bound to consider them.
We are prepared to live by the outcome. Once the chairman makes a declaration, which I hope is soon, we will abide by that declaration. The commission is bound to accept the report of the Chief Elections Officer. He is the authority. There's no other authority to prepare such a report. He is mandated to prepare a report. The report will include the tabulation and also the validation in the form of observation. And if the observation shows that there has been corruption, he is obligated to make such a report.
President Granger pointed to the CARICOM scrutinizing team's recommendations that irregularities such as missing documents from some ballot boxes be investigated, but failed to mention the team's conclusion regarding the winner of the elections. The CARICOM team stated in their report, "We are of the unshakable belief that the people of Guyana expressed their will at the ballot box, and as a result, the 3-person CARICOM observer group concludes that the recount results are completely acceptable." Granger accused the PPP of meticulously and methodically tampering with the electoral process to secure a win and urged that the entire CARICOM report be read as he criticized those who were looking at just the numbers.
We need to read the whole report. Some people are running away with the impression that because the numerical tally seemed to favor one side or the other. That is the end of the matter. But what we have found is that there needed to be a deeper investigation into the anomalies and the irregularities which occurred countrywide. And this has been done. And this has been a feature of the report by the Chief Elections Officer, which I expect will be presented to the Commission.
Despite reading the conclusion of the CARICOM team, the President said the Chief Elections Officer was quite in order to include those allegations in his report and that GECOM was bound to consider them. However, the Elections Law Amendment Act of 2000 states that the Chief Elections Officer and the Commissioner of Registration shall, notwithstanding anything in any written law, be subject to the direction and control of the Commission. But Granger insists that the Chief Elections Officer is the authority and there is no authority to prepare such a report. He said if the observation shows corruption, Lowenfield was obligated to make such a report.
We expect a declaration which is going to be acceptable to all of Guyana and also to the international community. That's where we are. The process is in the hands of the Commission. I cannot intervene at this stage. I've never intervened before, and I will not intervene now. We have a legal process. It is taking a long time, but it is a legitimate process. And let us wait to see the outcome, hopefully in a few days' time.
Claims of electoral fraud have been strongly condemned by the regional and international community. Even local stakeholders such as the Georgetown Chambers of Commerce and Industry, GCCI, have condemned Lowenfield's action, describing it as treasonous. Granger, in his Monday night interview, said he resented those who have spoken out about sanctions and penalties and said his coalition deserved a chance to win and continue its work.
Meanwhile, following that interview, leader of the opposition, People's Progressive Party, Bharrat Jagdeo, accused the president of being delusional. Jagdeo, in a Tuesday afternoon virtual briefing, said the president's comments were to a large extent, quote, factually wrong and downright misleading. He used his opening statements to blast the president for accusing the PPP of fraud, which he insisted are mere allegations by the APNU-AFC coalition, while ignoring proven instances of fraud committed by operatives within the Elections Commission in favor of the coalition.
I'm tempted today to take that tone. I'm tempted to take that tone of totally disparaging what he said and criticizing it as somebody who is delusional, out of touch, and being fed propaganda by his staff that he readily imbibes because he wants the same outcome. He wants to hang on to power illegally, knowing that he has lost the elections. And I'm tempted to point out that there's nothing decent about that.
Jagdeo was adamant that throughout the interview, the president never acknowledged that it was Clement Mingo, acting as the returning officer for District 4, that was the primary source of the fraud that led to the delay in the declaration of the election's results. The certified figures from the recount are at odds with numbers put forward by Mingo, showing inflated numbers in favor of the APNU-AFC, handing the coalition a victory. Jagdeo said Granger also failed to acknowledge that the country's chief elections officer, Keith Lowenfield, was prepared to make a declaration on the basis of that fraudulent report and now presents a report which invalidates over 115,000 voters.
There are things that I agree with in this statement. First of all, the process is in the hand of the commission. It is the commission that makes the decision. Not any court, not the CCJ, nor the Court of Appeal in Guyana. They will not make the decision for the commission. The commission is the only constitutional body that can make the decision and the declaration of the results.
Jagdeo said Granger seemed prepared to give polished support to vile rhetoric by the APNU-AFC campaign manager Joseph Harmon that he would not concede defeat at the polls. The PPP has been acknowledged as the winner of the elections by the regional and international community based on the recount figures. Jagdeo also poured cold water on Granger's claim that GCOM is bound to accept the report by the CEO. At a time when the incumbent APNU-AFC is leading a vicious campaign against the international community, former Minister of Foreign Affairs Karl Greenidge on Monday cautioned locals against shouting down foreigners who are needed by Guyana. Kurt Campbell joins us now with details.
The former Foreign Affairs Minister Karl Greenidge reminded that as a small state, Guyana needs the protection of the international community as it seeks to defend its territory from those who lay claims to it. In a telephone interview with two members of the incumbent APNU-AFC during a program on its Facebook page, Greenidge criticized his fellow Guyanese who in recent months have repeatedly reproved comments by the international community on Guyana's internal political governance and elections issues. His comments came hours before the International Court of Justice ICJ heard the Guyana-Venezuela border case, while citizens who voted in elections more than 100 days ago await an official declaration from the Elections Commission and the installation of the new government. Guyana also has a case before the Caribbean Court of Justice, CCJ, challenging a ruling by the Court of Appeal in the ongoing elections debacle. But amid these regional and international developments involving Guyana's sovereignty, supporters of the incumbent APNU-AFC coalition and officials of that party have been very critical of comments coming from the international community, which has called for the declaration of the results using the official recount figures. Those international bodies include the Commonwealth, CARICOM, the European Union, the Organization of American States, and local diplomats from the United Kingdom, United States of America, and Canada, among others. When asked for his input in these developments, Greenidge said he knows his position is not going to make many Guyanese happy.
If you have acted properly, you don't have to, at the same time, prove that you acted properly by censoring other people and shouting them down for voicing a view. If you acted properly, that will have to be taken into account by the court. So I'm telling you, I see a lot of the arguments in Guyana, even by very senior officials in the country about sovereignty, which are, let us say, inappropriate.
He reminded that Guyana was one of the countries that was most ferocious in the battle against apartheid, with its public statements pronouncing on court action and the lack of action by the government of South Africa.
This is not going to make many Guyanese happy, at least those who are fond of writing in the papers on such matters. You do not have the right to censure other people for pronouncing or giving a view on such matters. And I will close by reminding you that Guyana was one of the countries most vociferous in the battle, and people now forget, against apartheid.
Greenidge lectured that in 1648 what happened within the borders of Guyana was for the government and people to manage, and no other country could have invaded simply because it didn't like what was going on. But since that time, the United Nations have adopted principles governing human rights and rule of law, which means that actions taken within borders by governments can be the subject of international or regional court actions.
A country's sovereignty, and listen to me very carefully, a country's sovereignty needs to be very clearly separated from the rights of a political party or the actions of a political party. Okay? The sovereignty of Guyana has to do with the rights of the people of Guyana to the territory within which they operate. Within borders, actions of governments can be the subject of international or regional court action. Okay, so sovereignty has nothing to do with a court not being able to pronounce on something taking place within borders. If you're a signatory to a treaty, such as the Treaty of Chaguaramas, or a treaty on human rights, which we have in this region, Latin America, or civil rights legislation or civil society agreements, then you are subject to those principles which you signed up to.
We tell you now that the Canadian government is concerned about a prolonged delay of the elections result in Guyana. This has gone on too long, Michael Grant, the Assistant Deputy Minister of the Americas at Global Affairs Canada, said in a tweet on Monday evening. Grant said that as demanded by CARICOM, the OAS and the Commonwealth, the outcome should be declared based on the recount which was confirmed by the CARICOM observer team. The Canadian minister joined a list of other countries which have been calling for an end to the electoral process. Guyanese voted in the general and regional elections since March 2. The national vote recount shows the opposition People's Progressive Party winning the elections by 15,416 votes. Now, President David Granger has granted approval to the Chief of Staff of the Guyana Defence Force, Brigadier Patrick West, to proceed on accumulated leave with effect from July 1 until March 2021. A statement from the Ministry of the Presidency said that President Granger has since appointed Colonel Godfrey Bess to perform the functions of Chief of Staff. Others appointed include Colonel Trevor Bowman as Inspector General, Colonel Sherwin Anderson as Quartermaster General, and Colonel Roll Jarrick as Adjutant General. 51-year-old Colonel Godfrey Bess said it is an honor to have been bestowed with the privilege of serving as Chief of Staff of the Guyana Defence Force. Colonel Bess, who started his military career in 1990, served in command, administrative, staff and training appointments throughout the GDF. He has been serving as Quartermaster General since January 1, 2018 and has been responsible for ensuring that the GDF is well-resourced to carry out its mandate in any terrain. Colonel Godfrey Bess will be sworn in on Wednesday morning at State House. Still ahead on the newsroom, students in Santa Rosa COVID-19 hotspots still have to sit national grade 6 exams, and GMSA says it is concerned with the molasses. The Guyana Manufacturing Services Association, the GMSA, has expressed concern over the lack of adequate molasses on the local market to supply the rum industry. 2 days after it was publicized that the Demerara Distillers Limited, DDL, had to resort to importing molasses to meet its demand and will likely increase the price of its rum products, the GMSA issued a call for the resuscitation of the sugar industry. The association in a statement called for the democratically elected government to give priority to the resuscitation of the sugar industry through an approach which involves public-private partnership. Molasses is the major ingredient used to manufacture over 20 different varieties of rum by DDL. The company reported that it has had to import molasses over the past 2 years following the closure of 4 state-owned sugar estates. Before 4 of the 7 sugar estates were shuttered by the end of 2017, DDL bought all of its molasses from the Guyana Sugar Corporation, GAISUCO. The GMSA said it wrote to the government in 2018 to guarantee supply of molasses to small-scale manufacturers. The association believes the downscaling of the sugar industry has had dire consequences to the economy and other sectors which depend on the industry. Now, with over 60 confirmed cases of COVID-19 in Santa Rosa, Maruca Region 1, the National Grade 6 Assessment students still have to sit the exams on Wednesday and Thursday. Isnella Patwa joins us now.
Thank you, Avinash. Santa Rosa is now the new epicenter for the new coronavirus outbreak in Guyana. Students in Santa Rosa have not been attending classes to prepare for NGSA as teachers tested positive as soon as schools reopened early in June. Public Relations Officer at the Ministry of Education, Bruchelle Blackman, told the newsroom via telephone interview that it is unfortunate that so many teachers tested positive in Santa Rosa, but teachers are not required to be in the school for the exams.
The examinations are going ahead as planned under the, as is guided by the examination order which was published and gazetted. So I don't know what else outside of that I can say.
No, with the high number of cases in Santa Rosa, will the students still be coming out tomorrow and Thursday to write the exams?
That's what I'm saying. The exams are still going ahead as planned.
2 NGSA students in Letem Region 9 who tested positive last week will be allowed to do the ministry's placement exam, which basically means that students will be placed at a secondary school closest to where they reside and then write a placement exam a year later. Executive Director for the Amerindian People's Association, Jean LaRose, also told the newsroom via telephone Tuesday that hinterland students are not prepared for the exam, especially those in Santa Rosa. LaRose explained that the APA had also written the National COVID-19 Task Force to increase testing in Santa Rosa when there were only 3 confirmed cases.
One of our concerns has been the unpreparedness of the children because of the lack of support to the communities, or lack of support not reaching the communities to prepare them in terms of the school curriculum itself and so forth. But the other one has been the slow pace at which support has gone to the communities to prepare them for the onslaught of COVID. In the case of Santa Rosa, well, the AP had written to the task force, the National Task Force, expressing concerns and asking that they step up testing and do a number of things specifically directed to Santa Rosa. Almost 3 weeks after, then we saw them kind of taking steps to do stuff in the community. This is when only, I think, 8 cases had been tested positive. So I know for a fact that there is not enough information, not enough awareness on COVID, its implications, and so forth, and therefore the community itself has been having a hard time dealing with that. So I don't think the children have been prepared enough. Okay. Or who is prepared? We as adults, we're nervous when we go out, except for those hanging out on the seawalls, of course.
Santa Rosa is the largest Amerindian settlement in the country, but with the slow pace of response to the community, there is now a high increase of positive cases. Added to this, Santa Rosa's Tushaw Juanita Phillips had told the newsroom that residents were not adhering to the COVID-19 curfew and other measures in place. Santa Rosa reported its first COVID-19 case on May 25th. 59-year-old Vincent Torres had visited Georgetown shortly before his death, where he is believed to have contracted the disease. With limited isolation facilities, the Civil Defense Commission, CDC, installed a number of COVID-19 isolation tents at the Sheba Ground in Maruka. Isolation facilities were previously set up at the Amerindian Hostel, the Regional Education Officer's residence, and the Aquero Guest House. Back to you, Avinash.
We tell you now that the Georgetown Public Hospital Corporation has implemented a number of COVID-19 measures to protect staff and patients, but persons who have relatives admitted at the institution continue to pose a challenge. Strategic Planning and Communications Manager at the hospital, Shalina Providence, spoke with the newsroom and explained that some of the relatives can be aggressive to the staff at the hospital and in turn make it more difficult for COVID-19 measures to be implemented.
I think there are 3 things I can think of immediately. One is that it's so new. I mean, we've been dealing with it for just about 6 months, globally for about 9 months to a year. And I think there's new information every week, and just keeping up with that and learning or knowing how to advise persons, how to advise our staff, our patients, their relatives, that has been one of the difficulties, because the information changes ever so often, and there's also so much misinformation out there that people tend to cling to. And so even as we share information, we have to deal with persons relying on information that is not factual to inform their decisions. The challenge with that, my second point, is that persons have not necessarily been adhering to the advice that is coming from reputable sources such as the ministry, PAHO, the hospital, and other health experts. And while we understand not everyone may get critically ill, what we want people to understand is that they can transmit to other persons who are likely to become critically ill. I think the third challenge has been the emotional and the psychological component of it. Like I said, our staff have been working so hard. I know so many staff personally who've been making major sacrifices, being away from their families, having to make major life adjustments because of the kind of work that they're now doing due to COVID-19. And I think every time we're faced with a situation where persons are not adhering to advice, where we have persons challenging our staff when they come to the hospital simply because they feel like two of them should accompany a patient rather than one, it can be difficult for our staff, and then there's like I said, we don't have a perfect system, we don't have perfect staff, but I think they have been working really hard, and it can be really demoralizing for them sometimes too, when people, make it difficult for them to do their work, if I can put it that way. So those are three of the challenges that I can think of immediately. Of course, there are several others, but those have been, for me, the most challenging three. As you know, we have put measures in place to ensure that the hospital is safer during the time that we're dealing with COVID-19. One of those measures is that we have limited, or we've restricted visitation to the hospital. The gazetted order says no visitation to hospitals. As a corporation, we understand that persons who have sick relatives in some of the wards might need to come and visit to provide them with meals or clothing and even emotional support, if we can put it that way. And so while we have restricted visitation to the hospital, we've also allowed some flexibility for some of our patients. For some wards, there is absolutely no visitation. Infectious disease ward, of course, any patients who are in the hospital who are suspected to be COVID-19 positive, who haven't had a positive result as yet, we do not allow relatives to visit them because of the likelihood of transmission. As it relates to our accident and emergency department, most of our patients enter the hospital through A&E. A person gets into an accident, they're feeling a pain that they can't describe, they come to the accident and emergency department to get treatment, immediate treatment, care and treatment. We have insisted that for this period, only one person can accompany that patient. And reason being, sometimes that person is unable to walk, and like I said before, they need the emotional support when they're coming in the hospital. You need someone to give the nurse or the doctor their medical history, to give them their information and so on.
Now, Region 9 on Monday recorded its third COVID-19 case, with that person recently returning home from Brazil. The third male patient also has citizenship in Brazil, where he spent most of the time before returning to Guyana in June and was placed in quarantine, according to Regional Health Officer Dr. Nayal Uthman.
Guyana and Brazil have a peculiar relationship. There are persons who have dual citizens in Guyana and Brazil. There are many persons who work in Guyana but live in Brazil, and vice versa. And that is how people cross. According to the immigration regulations, you cannot stop a Guyanese from coming to Guyana, and neither can you stop a Brazilian from going to Brazil. So from time to time, Guyanese come over to Guyana that live in Brazil, and vice versa. When that happens, you have to quarantine persons, and that is how this person was quarantined. A subsequent test proves that they are positive.
Brazil has recorded the second highest number of COVID-19 cases globally. Recently, 2 students who returned home from Brazil to write the National Grade 6 assessment tested positive for COVID-19. There are 12 persons who remain in institutional quarantine in Region 9. When the newsroom returns, the financial, weather and bridge reports along with sport. Stay tuned.